Any mention? May I please, Your Lordship? I beg to mention item number 33. 33.
23.
33, madam. 33.
I have no objection.
Yes, what do you want?
After 4 weeks, my lord, because in other courtroom also there is some hearings going on. So after 4 weeks, if the matter may come up.
What connection it has with the other hearing in other courtroom?
No, my lord. Actually, there are, in other courtroom also there will be hearing. So I need some time to prepare for this hearing.
Just a moment, just meet on the other end. Just a minute, I've got 4 weeks. Yes.
Daily causes, item number 1.
Yes.
My lord, these are similar matters with the earlier one which your lordship has passed those orders, 18 matters, my lord. It's almost similar matter. The only difference here is that, my lord, the present batch of... Yes, same, almost similar, my lord. Only difference, my lord, in this case, my lord, they have been discontinued, my lord. This batch of items.
So here it is not only revocation of regularization, it is
Discontinued one.
This other one, they were not regularized also, my lord. Your lordship will see item number 2, number 3.
okay. See, anyway, let's just not pass. Just this is the first one. This regularized.
Regularized.
Yes.
Just Mr. Dean, one thing you don't understand. Person was employed schedule, was holding casual status.
Yes.
Now he regularized. And thereafter employment.
That's why, my lord.
But then if you regularize somebody, then definitely
Regularization.
you may say that regularization was done also. But then was it not that you see, like prima facie, it shows something. You do not say like from the you may have you say like justification for doing so. You see, maybe right.
True, my lord.
But then the thing is that what is the need of regularization? You could have you see, it is the same committee which engages them.
That is the problem, my lord. It is not the same committee.
That is for you, but then for us, for our court, it is just, we do not know what happens.
Yes.
We are concerned with law only. The moment you confer to regularize on somebody, it is assumed that regularity, what was there in appointment, was correct.
My lord, I will satisfy your lordship on that because that's why I am going to file my affidavit. Regularization by itself is not a mode of appointment. Now, Supreme Court has time and again held that.
It can be.
I will satisfy your lordship.
It can be, definitely. We are not saying this. But then regularization confers a better status than the casual employee, isn't it?
For all casual employees, there is no sanction post. In these cases, there is no sanction post.
Is it not that for you to see before you regularize?
But it's for us to see now because my lord, these are 73 posts. The difficulty with us right now, the executive committee, we don't even have the funds
My lord,
to pay the employees.
These are grade 4 posts.
grade 4.
Some are grade 4, some are engineers also.
But these are before your lordship, all the grade 4, my lord.
These are before your 3
Peons,
years.
process server, Mali, my lord.
Right now, we are concerned with grade 4.
Society, my lord.
As per the service, so what is the mode of appointment of grade 4?
That is by way of advertisement and a competitive exam.
You have that.
Yes. We have the rules. I'll file my affidavit, my lord, as I said, by tomorrow, day after.
Then we will pass the same.
Yes, in the first one, in this number 1.
And then how many are there is no casual? I mean, like no
Now, the other, my lord, your lordship will see.
where there is no regularization, will not pass any.
My lord, the other the item number 2 onwards, my lord, as item number 3 onwards, they have been appointed, my lord.
Number 3.
As-
Anyway, so how many are like this, similar to this number?
Only one.
Only one.
Okay. So this will be like this in previous order. Okay. Okay. This is just you may have you have the copy of the earlier order. Do you have you have to pass. So in the main you just saw in the main petition, hard Mr. So just Mr. Kelly, non-counsel for the petition and also Mr. non-senior assisted by. And so for the respondents, we should notice returnable in 2 weeks.
No, my lord, these are returnable actually on Thursday, the other ones. So I am filing my affidavit by day after tomorrow, my lord, in all these matters,
Including these matters.
including these matters. List it along with, let it list it along
It may
with.
happen like that after you file the affidavit, they may have some whatever it is. Anyway, so we'll have it on Thursday.
Thursday.
So, but then, is there any need of then issuing notice? Any, since you have to file affidavit, you have to, and just say issue notice, returnable on Thursday, just to be specific.
Thursday. Returnable on Thursday.
What's coming up on Wednesday, the arguments?
Okay.
So it means day after tomorrow. Yes, then will be okay. 2 days will be okay for me.
Yes. In fact, they are ready.
Just say issue notice, returnable in 2 weeks. Returnable in 2 days. Returnable by day after tomorrow. Day after tomorrow it is.
Yes.
Yes, as long as senior counsel is happy with the respondent submits that the counter affidavit will be filed before the returnable date. Yes, we give the submission. This is letter for admission hearing on same day. Okay.
Along with those other.
And then in this
And I,
noted order passed earlier, this. What is the order? Let's what is the first order by which you have been appointed on
that's
casual basis?
annexure 1, my lord, if your lordship come to page 15, my lord. This is a type copy, my lord.
Yes.
By this virtue of this order, my lord, 31st August 2023, my lord, I was appointed as a casual employee, my lord.
What is your name?
Right, number 1, my lord.
Yes.
Yes, my lord. Subsequently, my lord, by annexure 2, I have been regularized, my lord. My name figures at serial number 8, my lord. Subsequently, by annexure 4, my lord, I was discontinued, my lord. Simply, my lord.
Regularization and regularization. Okay, then the same order will be
Same order.
near to order. Remember those earlier order. Just take from here. One of the slides. Yes. This is for item number.
My lord.
Item number?
This is item 2, my lord.
Yes. This is petition number. Yes.
235. huh?
Great petition number 235.
So this is not this thing. This this is yes. Next 7 item.
236.
Yes.
In this case, my lord, I was appointed directly as a peon, my lord, with a pay scale, my lord. Annexure 1, my lord, page 12.
So there is no casual.
No, my lord, not a
This is
question.
this is a appointment temporary. My lord will see para 2.
That is remains everywhere.
My lord.
Even in
But
regular.
again, you see, my lord, how,
It's a format.
Transferable and terminable without.
Even
how were the appointments done, my lord? 24th of January, that was 2 days before the Model Code of Conduct came into force.
That is for you to consider. We will not go into all those. Okay, so
And no advertisement, nothing. No.
My lord, I have been informed by my clients that there has not been a case of advertisement for the entire appointment in entire discount.
come to your thing also. We pass order on 29th May and making it effective from 1st June.
1st June.
Dividing them from even filing a representation to you also. Forget about sitting other than you. Come to page 16. So more or less, you see, like you.
It was issued on 29th May, my lord, with effect from 1st June.
Yes, so you have hardly given how many days in between? 30, 31st.
2 days.
At least,
Well,
they should have given at least something so that they could also represent it before you. That also is not there. Forget about
The question of submitting any show cause, my lord, in such cases would not even arise. Now, my lord, I will satisfy your lordship that the Supreme Court has time and again held that in case of irregular appointments or illegal appointments,
that is, see, how do you determine at this stage what is illegal and irregular?
we have to now we have to fall back on the rules, my lord.
No.
What does
See,
the rules contemplate?
But then for you it was something like an arbitral position that was an illegal. That is why I don't think that you want to say that the petitioner also admits that that is an illegal appointment.
No, we never admitted
The
that.
facts
my
are
lord.
not disputed, my lord. If the petitioner can show that there was an advertisement, there was an examination held, we will withdraw this termination now.
So that is not your case, is it?
No. But my lord, the entire till today, right from 1972 till 2025, my lord, 90% of the appointment in this council is done in this manner only, without advertisement, my lord. So I have seek an RTI to that effect also, my lord. They have not been able to give me the advertisement, my lord.
What happens in
Yes.
if a wrong continues for a considerable period of time?
My lord.
Can you say
Can you
that
say
wrong
it's-
becomes
My lord, why should I be victimized for that, my lord? My lord,
See, Mr. Korean, you should
My
know
lord.
one thing is that there cannot be a case of negativity.
my lord.
Just because there exist other numbers of
Your lordship.
police,
Your lordship.
those who are illegally
My lord.
their appointment they are retained. You just cannot come and say, see, legal appointments are retained, I should also.
My lord, but I have been victimized, my
Two
lord,
wrongs
if that's the case.
won't make a right, my lord.
I have
Because
been
that's why
I have been
Umar
victimized, my
Devi,
lord, in this case.
Your Lordship, Umar Devi case, that's why paragraph 54 has given that thing, 10 years. Those persons who have served for 10 years, Umar Devi had given that option,
That is for one-term settlement.
one-term settlement. That option was given because of all this.
That you appoint somebody, allow them to complete 10 years in a
My lord.
That was
That one for
taking
one,
the
yes.
situation
One.
that matter.
I was reading
One time.
Umar Devi, my lord, and I got this paragraph.
But cannot be a different.
Liberty to
No.
appoint person casually, make them continue for 10 years and then.
My lord, cannot be a different yardstick, my lord. For one person, it will be a different yardstick. For me, it will be a different yardstick, my lord.
That is like again same thing. That is the question of negative.
My lord.
That is where you see the equality.
Equity have to be prevailed, my lord.
Equality will prevail when things are done legally. But in illegal appointment, equality does not. That cannot be legal.
Anyway, my lord, we'll file our.
File, but then will state is still.
Your lordship.
We do not have the order of RD referee order.
You should give.
So we'll provide, my lord.
Not be on.
My lord. Your lordship.
Anyway, we will pass this order.
Your lordship. Your lordship.
And if you
My lord,
So far as the main date is concerned, all same, issue notice, determine so. Okay? It means day after tomorrow. Then record senior counsel submission, so if you fight, then thereafter you give some.
my lord, item 3 to 7, my lord, is similar.
Same situation.
My lord, same, my lord. They have been directly appointed and
Then the impugn order is also same, dated same.
impugn order, my lord, 20.
Mr. Hari, in this kind of cases, it's always better if you give a chart.
My lord.
It becomes
Chart, my lord, as far as the post and I have.
post and then date of
Post.
appointment and date of. Or if regulation is a regulation. Anyway, it's all.
My lord, we'll provide a chart, my lord, if that's the case. My lord. Obliged.
So to 8
2 to 8.
Item number 9.
Yes, my lord. Yes, my lord. My lord, I begin my submission at page number 5 of my writ petition, please, if I may. The petitioner is currently posted as the member secretary of the Meghalaya State Pollution Control Board, having 13 years practice, and his tenure of service is the next page at page 6, my lord. He's the member secretary of the Meghalaya Pollution Board, and he draws a salary at page number 7 at level 19, my lord. Pay scale salary of level 19. Now there's an advertisement, my lord. Not advertisement, sorry. There's an act which can be called for IAS appointments by selection, that is from non-state civil service officers. You can call, as per the recommendation, my lord, you can recommend officers from various departments to the IAS person. Yes, nominated. Thank you. Yes, nominated. So as per this notification dated 19/9/2024, latest.
Criteria has been laid down for
Yes,
nomination.
yes, my lord. It is found at page 58.
You are seeking nomination.
No, my lord, I've already been nominated. I have already been nominated, but the thing is, there is an amendment in 2017 which the Forest Department do not have the level pay scale 18 as per the eligibility, as per the criteria of this regulation 4 of the IAS appointment selection regulation 1997. Can I just read it and show you? This is found at page 58.
Who has not understood what your grievance is?
My grievance here is, my lord, that I do not fall under this pay scale. My pay scale is pay scale 19. But
Your name has been nominated.
my name is nominated. However, I have sent the course of action here is, my lord, I have not heard from them. There's only one post available for this nomination. So the thing is, I have not heard from them, and also, my lord, that I have not heard from. I have not. There's no.
You say you are nominated, then what is the question of what?
No, my lord, I'm not. There has to be a selection process. There has to be. Yeah.
Your name is nominated. How you should be both?
I've just not my lord. It's just
Recommended,
recommended, not
name was
nominated.
recommended by the
my
department,
lord.
my lord.
Recommended.
My-
Yes, my lord. Thank you. I'm sorry. I've been recommended.
Who could not understand this?
Sorry, my lord. I have been recommended. So now my grievances here is that, my lord, if I do not fall under the pay level of 18, I might be not I might not be
See,
held.
after your name is recommended, then who considers?
The state selective committee.
Now, is it that they have rejected your name?
No, not yet, my lord. So the thing is,
This is not
I-
this is premature.
I'm also asking for other prayers, my lord, that there has to be a prescribed syllabus, there has to be a written examination, there has to be.
If your candidature is rejected, then we will come to you. See, what is the question of? Is it not premature?
No, my lord, because
What is the cause of action? Just tell us.
I'm telling you, my lord, my course of action here is that because other states are following a certain procedures, our state yet has not prescribed these procedures till date, such as what is the syllabus, such as what is the criteria. I mean, what is the examination, what is the way of selection. That is not there, my lord. I do not know, and since there's no transparency, I might not be selected.
Can you assist for filing a petition?
Yes, my lord.
Just give us some that it can be.
That contemplated rejection.
Yes. No, I am not competent. I'm not contemplating rejection, my lord. I may or may not be.
My lord, here, if my lord will see paragraph 4, page number 4 of their writ petition, my lord, paragraph 3. My lord, it prescribes what are the requirements, my lord. I'll just read these relevant portions, my lord. That the petitioner herein is currently posted as the member secretary of the Meghalaya State Pollution Control Board, and as per notification number so and so, he is recommended by the Forest and Environment Department for consideration and inclusion in the select list of non-state civil service for appointment to the Indian Administrative Service (IAS) under the Personnel and ARA Department, dated 19 September 2024, in accordance with the Regulation 4 of IAS Appointment by Selection Regulation 1997. The state government proposed to consider the case of non-SCS officers for appointment to the IAS for one vacancy under the following conditions: is of outstanding merit and ability, holds a gazetted post in a substantive capacity, has completed not less than 8 years of continuous service under the state government as on 1/1/2024 in any post equivalent to the post of deputy collector in the state civil service level 18 of pay matrix shall not have attained the age of 56. These are the requirements. Here, my lord, the petitioner, admittedly, she has served for 5 years, and that too at the level 19. And her grievance is that there is no level 18 as far as where she is.
Above 19, so this cannot be disqualification criteria.
Yes, my lord, but then I have not heard
This
from.
is an added thing, isn't it? 19 is above 18, isn't it?
No, but here the requirement what it says is level 18 of the pay matrix. Her contention.
Are you contemplating to reject her candidature?
No, my lord, I need instruction because this is for the first time. However, my lord, even as per the requirements which is mentioned here, it requires 8 years of continuous service in level 18.
She has.
I have.
She do not
I have.
have it because she is
have.
continuously serving for 5 years, admittedly.
It means like there is a likelihood that you will reject.
My lord, I cannot say at this moment anything, my lord. I will require instruction.
So far as it seems to the court, you have to go by the writ petitions. Her name stands recommended and it is yet to be. So at this stage, there is no cause of action for filing it.
Right, right. There is no cause of action, my
If
lord.
it comes to that you disqualify her because of her not getting the salary of level 18, then okay, that she may have evidence.
Yes, yes.
Please you take it.
Yes, yes, my lord. Please.
That is the only thing we can do.
But I have other prayers also, my lord. If I may, I'm also my grievance here is that, my lord, there's no syllabus been framed till date. There's no.
Let them take it. Let us take you see that there is no question of asking me.
There's no procedure for.
We need to not be
All right.
Yes. You will appear for all
My lord, 1 and 2, my lord.
3 and 4. Any standing laws for them?
No,
Oh, my lord,
I'll tell you.
notice has to go ahead.
Yeah. Notice has to be issued, my lord. Thank you. Thank you for correcting me for domination.
Always.
Yes.
Item number 10.
Please, Lordship. This matter, Your Lordship, I seek some more time to file my affidavit. This is regarding Lokayukta, where the charge has been filed against the petitioner. So they have challenged. So I am the complainant actually. Now here I am the respondent.
Yes, Lordship. There's some procedural files. No, Lordship. There's a repetition, criminal. There is an interim order, Your Lordship, staying the proceedings.
Let it continue. I have no objection, my lord.
Miss case, Lordship.
Let it continue, Lordship. Since I have not filed the affidavit, I am not objecting, Lordship. Resolution number 2.
One is statement.
I'm the.
You will filing in your
No, madam.
way.
My lord, let
You are supporting the petitioner.
my lord, let the respondent number 2 file his affidavit.
It's a writ petition, so you will not find any opinion.
My lord, in so far, my lord, we are not, because we have not received any instruction.
That is okay, but shall we record it that you submit that you are not going to file?
My lord, as of now, my lord, as of now.
So,
Let the affidavit of the respondent number 2 comes, if required, my lord, we will
you
be
are not
filing.
supposed to rely on the evidence.
Then, my lord, kindly give us time to have a complete
See, it is
instruction
for
when
you,
we file
it is for you to take a stand. Your stand cannot be dependent on the stand taken by the.
My lord, I will take instruction, my lord.
So that is what, so we will grant time to both of you.
My lord,
Later on, if you decide not to file it,
my lord,
obviously after the 2 meetings,
my lord, yes.
then you can come with.
Respondent number 2 is affidavit.
Then we just, at this stage we will just say, Ms. R. Tony, on it also.
After filing. I'm 2.
For the 2 weeks time is granted. 2 weeks.
Lordship.
Counter affidavit.
Much blessed, Lordship.
Obliged.
Much blessed, Lordship.
Item 11.
May I please, Your Lordship? Your Lordship, I'm praying for further 1 week time, Your Lordship. Further 1 week time to prepare the paper book. It's almost ready, Your Lordship.
12 and 13 are connected, Lordship. Lordship, let it be 2 weeks' time, Lordship.
Lordship, item number 13 I am appearing. I am praying for same prayer.
Is there a connected matters?
Pardon?
Arising.
12 and 13 is similar.
Lordship.
So in both the matters, paper book is yet.
Awaited, Lordship.
Okay. 2 weeks.
For that 2 weeks time is granted.
I'll have it.
Much obliged, Lordship.
14.
Yes.
Lordship, I have to file the affidavit in service report. Lordship, kindly allow me to file during the course of the day.
And then whether they have been served.
Yes, Lordship, they have been.
And then after we file that, what will we do? Any partial filing. Record filing first.
Yes, my lord.
London Council Court petition, phase 4 and phase 4 and phase 4 and these guys. And just say the London Council Court petition is
Yes.
15.
Lordship, I have taken the steps and the copy has been received, so I may be allowed to file my affidavit in service.
we have served by justice.
Both, Your Lordship.
Please, Lordship. This in the private respondent, I'm entering affairance, Lordship. This item number, the respondent number 6 is a private respondent.
What is to be done?
So I'll be filing my Bakaratnama today. So today only I received this notification.
What about 5?
The 5 is
Your Lordship, I'm entering appearance for respondent number 5. I will file my power today, Your Lordship.
Your Lordship, steps have been taken, Your Lordship, from my side. Yes. Yes.
Yes, yes.
Just
Lordship.
Please time to grant it.
Lordship. Lordship.
I don't know whatever in this period. Yes, sir.
Deeply obliged, Your Lordship.
As soon as Lordship.
17.
Lordship, they're supposed to bring the instruction in this matter, Your Lordship. There's earlier order, the government supposed to give some instruction they're supposed to.
Lordship, I have been informed today through phone call, Your Lordship, that they will be processing the salary, Your Lordship. However, I need a formal instruction, Your Lordship.
That is better. Whatever instruction you have, if you put it in writing, you can supply it to us.
Lordship, please grant me some time, Your Lordship.
Yes, Lordship.
You're going to have some writing affidavit.
Yes, Lordship.
We'll just give you some more time.
Lordship.
Yes, Lordship. No problem.
Yes, Your Lordship.
Rather 2 weeks time is granted.
3 weeks, Your Lordship.
Lordship, no.
3 weeks granted.
At the meantime, let it process.
This is 3 weeks is given on the understanding that you will come up with some positive result.
Your Lordship.
Most praise, Lordship.
80.
Lordship, the state respondent has to file affidavit, Lordship.
We have sent for instructions. You are awaiting for that. So I'll pray for 3 weeks.
And with regard to 6 and 7 private respondent, we have taken steps on 13/5/2025. We have write a letter to the post office, but status report is yet to receive.
So then you file it. This is for the last order.
Yes, my lord. Yet to receive. The moment we will receive, we will file it. My lord, Hassan, my lord. Yes, my lord.
It would have gone as Hassan. If I say Atal wrongly also there.
My lord, my lord.
Hassan. Yes, I missed David in respect of this one number.
6 and 7, my lord.
Then you say also place for matter.
My
Lord, I'm still awaiting instructions.
my lord, yes, my lord. Highly obliged.
Hearing item number 19.
Yes.
John? You are joining?
Yes.
Yes.
My lord, she will join.
Your Lordship, the senior counsel is out of station, Your Lordship. So, that a matter.
Yes, some portion of the record has been obtained.
Some portions.
Yes, my lord. So on the next date, I will produce it, my lord, because I have to just classify, my lord.
Whether those portions cover up the.
Yes, my lord.
This is that case the issue of res judicata.
Yes, my lord, exactly.
2 weeks, Your Lordship.
The only thing is that the problem is that people forget whatever. That is a big problem. Just unfair made on. Are you there? I've got it on record in this case.
See the cost list.
Yes, Your Lordship.
What is the name? T? Let's check cost list.
And just one fair made on behalf of the
No.
Arguing counsel. Mr. Arguing counsel for the by Mr.
Let it be after 3 weeks, my lord.
No, we can prepare it next.
20.
Wait, please, Your Lordship. Lordship, we are yet to obtain some instruction on this matter, Lordship. Lordship. Petitioner, Lordship.
What is the matter about? And what for you are needed to take instruction?
Lordship, for the current status of the session case number 29 of 2017. Lordship. Lordship, order dated 08/04/2019, passed by the learned session judge, Lordship, Tura, in sessions case number 29 of 2017.
You are supposed to take instruction with regard to the status of the case.
Lordship.
Because here challenge is the order dated challenge is to an order dated 8/4/2019.
Lordship.
Okay.
Lordship.
By which the learned session judge director for framing of charges.
Lordship.
Now see, this is 6 years now.
Lordship. Lordship may have it next week.
Any information?
No, my lord.
You can also try from your team.
Yes, ma'am.
Just obtain the instruction. If say criminal case is not supposed to remain state for 6 years until unless there is specific order. So far as the case record, so far as it appears from the case record, there is no such order. So there is not should not be a futile exercise as or something like that. The court passes one order and then again we find that something else is missing. Okay. Just MS Khatun.
Lordship.
MS Khatun, Lawyer Counsel. Again for the petitioner. This will grant us some more time. Obtain necessary instruction in terms of order dated 29/4/2025 of this court. Respondents has not whatever you say, Mr. S. Addition of security. When?
Next week, Lordship.
2 weeks.
Lordship.
Make sure you have the instruction.
Lordship. 2 weeks. Obliged, Lordship.
21.
May
My Lord, my Lord, the petitioner in this matter and the connected 9 other matters, my Lord, petitioner, my Lord, is a member of the Meghalaya Civil Service, my Lord. Through the writ petition, my Lord, the petitioner is raising an issue of seniority for the reason, my Lord, that the private respondents have been placed in a senior position to the petitioner. It is the petitioner's case before this honorable court that that is not as per the, this placement of the private respondents is not as per the rules, my Lord. So if I can, seniority. If I can take a few moments of Lordship's time just to place some, highlight some of the background facts. If Lordship kindly looks at page 25. Page 25, my Lord, is a notification of 2010. It is through this notification, my Lord, that the petitioner was inducted into the MCS service, my Lord. Petitioner's name, my Lord, at this is for item number 23. Petitioner is at page serial number 29, my Lord. That is Srimati Banti Monbla. And just for convenience of this honorable court, and just to enable me to explain the issue better, if Lordship kindly turns the page, serial number 34, that is Srimati Twinkle S. Marak, is the first private respondent in item number 23. In item 23, there are 5, I think. How many are
My Lord?
all are represented here?
Everyone is. Everyone.
Only 10 of them they represent.
How many private respondents?
My Lord, I'll just explain. Till number 2 is the state, my Lord. Thereafter, 3 to 15 are private respondents, my Lord. 3 to 15. Yes, my Lord.
How many are represented and how many are not represented?
My Lord, my friend Mr. Momin is appearing for most of them. He might be in a better position to state who is not representing, my Lord.
Representing respond number 3, 5, 7, 8, 10, 11, 12, 13, 14 and 15.
So left out, who are left out?
There are three left out, my Lord. Respond number 4, respond number 6, and respond number 9, my Lord.
4, 6, 9 are not.
Yes.
But they in service, they are in service.
Yes, sir. They are not for sound to go.
But notice has been served, my Lord. We have also filed affidavit of service. We have. Now, going back to page 25, my Lord, the notification. Petitioner, my Lord, is at serial number 29. And first private respondent, that is respondent number 3, is at serial number 34, my Lord. Now, this notification, my Lord, is important because if Lordship looks at the first paragraph of the notification, the result of the interview conducted by the Commission from the so-and-so for recruitment to the post of MCS and MPS under the Government of Meghalaya having been the following are the names of the successful candidates recommended by the Commission in order of merit. So, my Lord, this is a merit list. And in the merit list, I stand above respondent number 3. This was in 2010. Subsequent to that, my Lord, subsequent to our entering the service, respondent number 3 received appointment in 2010 itself to the post of MCS junior grade. And I received my appointment in 2012, my Lord, 2 years after respondent 3. Now this appointment I would submit, my Lord, is on this difference, my Lord, I would submit is on account of the reservation policy
in vogue, where certain sections receive prior appointments, etc. But in any event, undisputed fact is, respondent 3 received. Depending on the availability of My lord, availability of seats. So she received her appointment 2010. I received in 2012, my lord. If lordship kindly looks at page 27, notification of 8th May 2012, number 1, my lord, this is my appointment to MCS junior grade. Now, next page, my lord, page 28. In 2014, a gradation list was published by the government, my lord. This gradation list, if lordship looks at the first line, the provisional gradation list of the members of the Meghalaya so-and-so, as per Rule 16.4 of the MCS Rules 1975, is hereby published and circulated to all concerned. This list, my lord, this gradation list was prepared in accordance with Rule 16.4, which I'll just highlight for lordship's perusal. In this gradation list, if lordship kindly allows me to point out, page 40, my lord. Page 40, serial number 31, my lord. Serial number 31 is the petitioner. Serial number 36, my lord, is the respondent number 3. So, What about all other responses? They are below. They are below me, my lord. They are below me. So, my lord, my first humble submission, as far as this 2014 gradation list is concerned, number 1, obviously, evidently, it has maintained the position of the merit list. In the merit list of 2010, I was above respondent 3. In the gradation list, that same seniority or that same hierarchy has been maintained, my lord. Number 1. Number 2, my lord, this list has been prepared in accordance with Rule 16.4. And it has been well prepared in accordance with Rule 16.4. If lordship allows me to... This is a list of 2014, my lord, the gradation list. This Rule 16.4, if lordship is pleased to peruse. These are the Meghalaya civil service rules, my lord. Rule 16, my lord, is at page 8 of these rules. Page 8. At the bottom is Rule 16, my lord. Next page, my lord, would be 16.4. I'll read, my lord. The seniority of the members of the service recruited after the commencement of these rules shall be in the order in which their names appear in the list prepared under Sub-Rule 4 of Rule 6 or approved under Rule 8. This list prepared under Sub-Rule 4 of Rule 6, my lord, is the merit list. So 16.4 is very clear, could not be clearer, my lord, that the seniority of members shall be in the order in which names appear in the merit list. So, What about the proviso? Proviso, my lord, provided that the members of the service recruited in year under clause B of Sub-Rule 1 of Rule 5 shall be senior, it doesn't really apply if lordship looks at Rule 5. It doesn't apply to me, my lord. So, just to reiterate, my lord, Sub-Rule 4, very clear rule that seniority will be determined as per the position in the merit list, my lord. So, Irrespective of their year of joining. Irrespective of the year in which they were appointed to the post. So, for example, in our case, my lord, recruitment into the service is one thing. Recruitment was done in 2010 for everyone, my lord. That was the 2010 notification at page 25. Recruitment, having been recruited, as and when posts are available, as and when the reservation policy, the roster allows, I will be appointed to the post, to the junior most post, which is the MCS junior grade, my lord. I am recruited into the service on the basis of an examination, my lord.
So you want to say that recruitment is confined to the holding of the selection, nothing beyond.
Yes, my lord. Now,
Appointment is
yes, my lord.
you cannot use that term.
I have been recruited into the MCS or the IAS or any other service, but I am not yet appointed to any post due to non-availability, etc. The moment I am appointed is when, as the word suggests, I have been appointed into a particular post of the MCS. So I was recruited in 2010. We were all recruited in 2010 through a common competitive exam. Based on the results of those exams and the interview conducted, there was a merit list prepared. I was above respondents in the merit list. Subsequently, appointments were made.
Anyway, see, that issue so far is concerned. If you say Restaurant number 3 was appointed in 2010,
Yes, ma'am.
you were appointed in 2012. But in 2014, this thing, gradation list,
Yes,
shows you senior.
Yes, my lord.
At
And
that time, there was nothing.
there was no problem. There was no issue, my lord. There was no issue. So, like I had submitted, the 2014 gradation list, my lord, is completely in accordance with 16.4. It maintains seniority as per merit list, my lord.
And that was the final.
My lord.
That was the final list.
2014, there was subsequent list, my lord. I'll just come to that also. Now, the other reason why I say that this gradation list reflected the correct position is because of the law, my lord. Because of the law. The law also is very clear. Various judgments are there, including judgments passed by this honorable court, the single judge and division bench also. If lordship kindly looks at page 44 of the petition. Page 44, my lord, is a judgment passed by a single judge of this Honorable High Court. That was in 2023, August 2023. Here, my lord, there were there were a set of rules which had to be interpreted by the learned single judge. They were known as the Meghalaya Directorate Establishment Ministerial Service Rules. Here also, seniority was the issue. If lordship looks at page 51, that is where the rules are contained. Page 51, my lord.
Yes.
Page 51, right at the bottom, my lord, seniority. These are from the directorate rules, my lord. Seniority, rule 29. I'll read, my lord. So and so. The inter se seniority of the lower division assistants mentioned in clause B of sub-rule 1 of rule 3 shall be in the order in which their names appear in the result of the competitive exam conducted by the commission. Such lower division assistants shall be junior to the... It goes on, my lord. So here also, like our MCS rules, the seniority would be in the order in which their names appear in the merit list. Merit list prepared after competitive examination, my lord. So in the background of these rules, which are exactly similar to our MCS rules, the learned single judge was faced with a question, was faced with a challenge raised by the petitioner. According to the petitioner in this judgment, the petitioner had been appointed prior to the other officials. So therefore, the petitioner sought seniority over the others in view of the fact that she had been appointed prior in time to they had been recruited together through the same process.
And she joined.
She joined before, like our case, my lord. In that background, learned single judge, my lord, in this judgment, if lordship looks at para 12, page 54. Para 12, my lord. Though it has been reiterated and held in various judgments that the date of entry into a service is the safest rule to follow while determining the inter se seniority between one employee or the other, however, in the circumstances such as in the present case, where there is the presence of rules framed under Article 309 of the Constitution, which creates a distinction as provided in Rule so-and-so, the contention of the respondent number 5, 6 and 7 were the contention that the respondents number 5, 6 and 7 were not born in the service cannot be accepted due to the presence of a specific rule. Moreover, the interpretation of the petitioner to bring in a date of formal appointment into Rule 29 so-and-so cannot be accepted, as this factor is clearly not present in the rule. The judgments placed by the learned counsel for the petitioner are therefore of no assistance in the facts of the present case. So the finding was very clear, my lord, that when there is a rule,
the rule has to be followed. If the rule does not consider the date of appointment to be a relevant factor to determine seniority, you cannot import the date of appointment into the rule. The rule has to be followed and since the rule states that seniority will be on the basis of the merit list position, that has to be followed. This was the finding of the learned single judgment. This judgment was carried on appeal to the division bench. If Lordship kindly turns the page 56, Lordship himself, my Lord himself, was a part of that division bench which decided this matter in September 2023. If Lordship looks at para 3, my Lord. Para 3, ordinarily, when recruitment for many positions in the same post is conducted through a competitive process, the persons who gain appointment at the end of the process are graded according to their merit. In other words, persons who obtain higher marks in the relevant competitive examination are placed higher in the gradation list as against persons who obtain lower marks. In many cases, rather erroneously, the gradation list is mixed up with the reservation list. While the reservation list indicates how many of the recruits at a particular recruitment process would have to come from among the reserved categories, the gradation list prepared at the end of such recruitment process has no nexus with the roster. This is important. And has to be prepared according to the inter se merit based on the marks of the candidates at the particular process. So again, a very clear observation, very unambiguous observation from the learned bench consisting of my Lord also, that you cannot mix up the gradation list and the reservation list. My Lord. The gradation list stands by itself and is based on the results of the...
Is there any issue of reservation involved here?
It's not involved, but the fact that the respondents have been appointed prior in time to me because of the reservation policy, and I'm not stressing...
That's what you are saying, that is the reservation,
Yeah.
whatever. But then I don't think the reservation has any...
No. I'm not even raising that as an issue, my Lord.
It is not the stand of the state
Yes.
that the respondent number 3 is placed senior to you because of the
No.
reservation.
It is for some other reason. No.
That is not the case, Your Lord.
It's for some other reason, which I'll just explain, my Lord. Para 7, my Lord. Para 7 of this division bench judgment, my Lord. Page 58. Para 7. It is plain to see from the inter se seniority list of so-and-so that while the appellant herein ranked 68th in the merit list, the 3 private respondents ranked 58, 55 and 53rd in the same merit list. Since it is also evident that the merit list pertain to the same recruitment process, irrespective of when any individual actually joined the service, the seniority and gradation list would have to be on the basis of the marks obtained in the recruitment process and the positions in the merit list. Very clear, my Lord. Very simple, my Lord. Para 10, my Lord. Para 10, that is at page 60. Since the writ court has referred to a relevant rule and justified the gradation list on such basis, there does not appear to be any error committed or any room for interference therein. Appeal was dismissed, my Lord, with cause. So the position, my Lord, that comes out from this judgment, which has interpreted and understood a very similar rule to our MCS Rule 16.4. The position is very simple, my Lord. Gradation list cannot be mixed up with the roster, the reservation list, number 1. Number 2, irrespective of when actually appointment was done, seniority would be as per the rules. In other words, seniority would be as per your position in the merit list matters. So this is the position summed up of the single judge of the learned single judge's judgment and honourable division bench's judgment. The stand of the state in this background, my Lord, is important. The stand of the state, my Lord, is contained at page 49.
Now, before you come to that,
Yes, ma'am.
just tell us what is your cause of action?
My cause?
2014 years.
No,
what you are challenging?
My Lord, there was a subsequent gradation list published, 2022, in which I am below the respondent. That is my
Your cause of action starts from
22.
Till 2021, you were treated as a senior
To the respondent. Then subsequent, there were some other developments also in between. I'll just take a few minutes to highlight those also. But prior to that, my Lord, if I'm allowed, the stand of the government, my Lord, because the government, with respect, cannot take a different stand in our case today. In our case today, page 49, my Lord.
Page 49.
Yes, ma'am.
That is the judgment.
Of the single judge, para 8, my lord. In brief, the arguments that have been advanced by the learned AAG Mr. So-and-so for the state respondents is confined to the fact that the service of the lower division assistant being governed by the rules, by application of the same, the instant case is covered by 9(1) of the rules, as the petitioner and the respondent numbers 5, 6, and 7 were appointed by way of direct recruitment from the same competitive examination, and as such, the inter se seniority was determined as per the merit list and by the application of rules so-and-so of the rules. So the stand of the government in this case was a correct stand, I would submit. Stand of the government was that since there was a competitive exam, the seniority would have to be determined as per the relevant rule, where the merit list reigns supreme. There can be no other criteria. Right. Now, so going back to our gradation list of 2014, I reiterate, my lord, it was well prepared. It was correctly prepared.
What bearing this argument of the state, which is division bench, will have in this present case?
Because in our case, my lord, my humble submission would be, our case is similarly situated. The respondents were appointed prior in time to me, no dispute about that, but only because of that, seniority cannot be granted to them. Seniority has to be in accordance with the rules and in accordance with the merit list, the position on the merit list, my lord. So to sum up, my lord, my submission would be that if the government has taken a particular stand in a particular case, which is exactly the same, where the same rule is there, the same kind of language has been employed, then in our case also, the government cannot take a divergent stand. Other defenses, other points may be there, but government cannot take a stand. Government will have to still submit that the merit list is supreme. Merit list has to be followed in determining seniority.
There cannot be two different years.
Naturally. So, the merit list of 2014, my lord, was well prepared. Subsequent to that, and this is important, my lord, page 61. Page 61 is a notification of 7th March 2022. I would say even the date is important, my lord. 7th March 2022. Through this, my lord, the members of the MCS received my badge, received promotion. So we were all promoted on the same day, my lord. So respondent number 3, today's respondent number 3 is at serial number 1. I am, my lord, at serial number 15. And this is not in order of merit or anything, it is just a list, my lord. Yes, ma'am. So this was 7th March 2022. We were all promoted to MCS senior grade, my lord. MCS senior grade. Now, I will submit and I will demonstrate how this is a crucial fact, the fact that we received promotion on the same day through the same notification. This fact is crucial in view of the defense that the the state is attempting to raise against my claim of seniority. If I'm allowed to point out, the problem started, my lord, as I had submitted in 2022, page 66. This was a fresh gradation list. Of 2022, 22nd August 2022. It says the provisional gradation list of the members of the Meghalaya Civil Service as per Rule 16.4 of these MCS rules is hereby published. So therefore, this list also claims to have been published in accordance with 16.4, which I just highlighted. But Lordship will find page 70. Prior to that, 71, my lord. Page 71. Page 71, my lord, serial number 46. I am there, my lord, petitioner. And surprisingly, my lord, serial number 32. Serial number 32 is the respondent number 3. So therefore, what has happened is very clear. 2014, I was above respondent number 3. 2022, the next gradation list, I am below respondent number 3, my lord. Now, naturally, this this gradation list. So, naturally, my lord, this was a cause of concern and distress. Representations were advanced, my lord, page 77. And after a lot of follow-up, page 85 reply was given. Page 85, my lord, a very cryptic reply at page 85, Annex 11. Page 85, if I'll read, my lord. Madam, with reference to your representation on the subject cited above, I am directed to inform you that the gradation list published on so-and-so is in continuation of the gradation list published on so-and-so in pursuance of the High Court judgment dated 10th February 2022. In light of the above, I am therefore to inform you that your representation dated so-and-so stands disposed of. So government took a stand that there was a judgment passed by this Honorable High Court on 10th February 2022, because of which the hierarchy has been inversed. I have been placed lower than the private respondent. Now,
in that judgment,
yes,
you were not.
I was party.
We'll place your lordship.
Anyway, you say, Mr. Jindal,
Yes.
We'll place your lordship.
Now, this judgment of 10th February 2022 was passed by Justice Banerjee, the then Chief Justice of the Honorable High Court. This judgment, my lord, I will submit, changes nothing. And I will demonstrate how it changes nothing. I will submit further that it is, in fact, if anything, not against me. It is not against me. I'll demonstrate that. If Lordship looks at the first paragraph, just to get an idea of the issue, first paragraph of this judgment, the 2022 judgment. The only question which falls for consideration, and the date of the judgment is important, my lord, may kindly note, 10th February 2022. I received promotion on 7th March 2022, about almost a month after this judgment. Now, first paragraph, my lord. The only question which falls for consideration in this matter pertains to the inter se seniority between groups of persons in the Meghalaya Civil Service and the Meghalaya Police Service. The principal ground urged by the writ petitioners is that since the writ petitioners were appointed earlier in point of time than the private respondents herein, there can be no question of ascertaining any inter se seniority between the writ petitioners and private respondents. I'll just pause, my lord. So today's respondents, my lord, today's private respondents were the writ petitioners in these 3 writ petitions. So 3 of the private respondents today were the writ petitioners there. I was the respondent in this 2022 writ petition, my lord. And the challenge that was raised by today's private respondents was because they received appointment in 2010 and I received appointment in 2012, there cannot be any inter se seniority to be calculated or determined between us, my lord. In that context, if Lordship kindly looks at para 10, my lord. I'll read, my lord. Para 10. It transpires that in 2012, a seniority list was prepared, and in such list, the persons recruited in the year 2010 and the persons recruited in the year 2012 were clubbed together for determination of inter se seniority among them. This was patently absurd and completely without any element of rationality or logic. It is elementary that an inter se seniority list assumes that all the persons in such list were appointed simultaneously, whether on the same date or in the course of the same exercise. A person who has been recruited or appointed earlier in point of time than another in the same post can never be equated with the person appointed later even to the same post. The very need for preparing an inter se seniority list arises upon a number of persons having been recruited to the same post simultaneously or by the same process. It bears repetition that if several candidates have been recruited or appointed to the same post on the same date or in course of the same exercise, only then would their inter se seniority need to be determined on the basis of the criteria which are fixed therefore. I will request my Lord to kindly make a note of on the same date. If the recruitment or appointment is on the same date, only then would inter se seniority need to be determined, my Lord. Moving on, para 18, my Lord. Extremely relevant and crucial, my Lord. Para 18. Para 18, my Lord. It is submitted by some of the respondents that the real issue pertains to the subsequent promotion that the 2010 recruits and 2012 recruits must be eligible to obtain. It is not clear as to how the promotion from the same post to the higher post in this case has to be determined, and the rules of the employer in such regard have to be adhered to. It is possible that the promotion is on merit cum seniority basis, where a separate set of considerations will come into play than when promotion is on the seniority cum merit basis. Whatever be the case, it can never be lost sight of that the 2010 recruits, which are the petitioners in the present case, came to be appointed in the same post much earlier than the 2012 recruits and will always be regarded as senior to the 2012 recruits in the entry level post. I will request Honorable Court to kindly note this. Regarded as senior, 2010 recruits regarded as senior to 2012 recruits in the entry level post. Moving on, that is the MCS junior grade. Moving on, as to how the seniority at the entry level post will determine the future promotion is an altogether different kettle of fish and is not the subject matter of the present discussion. So what learned single judge Justice Banerjee had stated was that 2010, that means the respondents, will be senior to me, 2012 recruit, only as far as the entry level post is concerned, number one. Number two, Justice Banerjee was very clear. How promotion is to be conducted, what happens after promotion, I am not discussing, is an altogether different kettle of fish and is not the subject matter of the present discussion. So, entry level post, they are senior. Justice Banerjee has said so. It remains so. Para 22, my Lord. Para 22. Again, important. WBC number so and so are allowed by holding that the 2010 recruits to the entry level posts have to be regarded as senior to the 2012 recruits to the same entry level posts, that means junior grade, irrespective of whatever future considerations may arise in determining the cases for promotion to the next level. So therefore, my Lord, the position has been determined as far as the entry level post is concerned. What has changed the position dramatically, I would say, is my promotion, which was conducted about a month after this judgment. So till that time, till the time I was in the entry level junior grade post, 2010 recruits, respondents were to be senior to me. I cannot dispute that. The moment I was promoted, on the same date, that too, then different considerations have to apply. Seniority cannot keep following. Well, I'll just come to that. So this judgment, I would say, to sum up my response to this judgment, I would say.
Say supposing if you accept your argument.
Yes, ma'am.
Then reference to the judgment.
Yes, ma'am.
Which is appended with your writ petition.
Yes, ma'am.
Becomes meaningless. So these all concerns are treated.
My Lord,
that means then there stands a contradiction in your stance over as these.
No, my Lord. No, my Lord. The reason I was required to address this judgment to highlight that it deals with only the entry-level posts is because of the insistence of the state. That it appears that the state is reading this judgment or considering this judgment to have determined the position for all time to come. So for all time to come, I am to be considered as junior to 2010 batch, 2010 recruits, the private respondents, my Lord. That cannot be. This judgment determines the position as far as the entry level post is concerned. They are my senior. The moment there is a promotion and we are talking of a next level post, the senior grade MCS post, then rules have to be followed. The rule has to be followed. This judgment has no more.
Which part of the rule of
Rule 21 and 24, my lord. I'll just come to that in a second, my lord, if Lordship allows. So this judgment is important, my lord, because it is the stand of the government that this judgment has determined the position for all time to come. That cannot be, my lord. It is very clear in its own language that it only speaks of entry-level post.
It's confined to the entry level.
Absolutely. And as far as promotion, what will happen after promotion, again, the language is very clear. I am not discussing. Justice Banerjee is saying, I am not discussing that. That is a different kettle of fish, my lord. So, so that being the case, I would submit, my lord, that it is very clear the stand of the government that this judgment ensures that I always remain junior to the 2010 recruits. That cannot be, my lord. That cannot be. A pointed question will have to be asked by this honorable court to the state, that have you applied the same logic to other batches also? Or is it just our batch which is receiving this special treatment, my lord? Answer is very clear. The same logic where date of appointment is important. When did you receive your appointment? That will determine your seniority. That logic is not being applied in any other batch besides my batch, the 2010 batch. Number one. Number two, if the logic of the government is to be accepted that this judgment has settled the issue for all time to come and has determined seniority for all time to come, then my merit list of 2010 has become a redundant piece of paper. That has no value now. The competitive exam which I appeared in, the competitive exam in which I was successful and performed better than others, the respondents, and where I was placed above the respondents, that has lost all value, my lord. The other pointed question will have to be, has the same redundancy of merit list been affected in the other batches? No. So that immediately, my lord, raises a...
How do then we correlate the judgment of
Yes, my lord. Yes, my lord.
with the 2014 gradation? Like, is it not that two things say two different?
So it is against the 2014 gradation list that private...
of the judgment of Justice Banerjee.
Yes, my lord.
Where your gradation list of 2014 is?
That gradation list, my lord, was put under challenge by the private respondents in those writ petitions. And it is the observation of the learned single judge, Justice Banerjee, that they have to be senior. So there has to be some change. 2014, my lord, I will not go as far as saying it loses its validity, because the specific issue that was raised in these three judgments, in these three writ petitions, was the contention of the private respondents, writ petitioners, that they are senior to me only because they were appointed prior in time to me. Because of this judgment, was 2014 gradation list amended or modified in any manner? My lord, I am not in a position to answer that. My lord.
Whether the single judgment was subsequently challenged?
It wasn't. It wasn't. It wasn't because, for the simple reason, my lord, there was nothing to challenge. Because the promotions were due. In fact, came 28 days after this judgment itself. And the moment promotions were affected, the judgment lost.
Supposing going by this judgment.
Yes, ma'am.
And we say that the private respondents were to be treated as senior to you, so far as the entry level.
Yes, ma'am. Yes, ma'am.
Now, how that seniority leaves? Because the position of seniority gets altered when promotion is affected.
My lord, if Lordship kindly looks at the rules, Rule 21 first.
Yes.
Rule 21. Rule 22, actually, my lord. Rule 22. Promotion to senior grade time scale. So from junior grade to senior grade, the promotion is controlled by this. Number one, a member of the service in the junior grade time scale shall be eligible for promotion to the senior grade time scale, but no member of the service shall be promoted unless he has served in the junior grade time scale for a minimum period of 7 years and the governor is satisfied about his ability, integrity, and character. Seniority in the junior grade doesn't play a part.
Qualifying now. Qualifying.
Yes, madam. The governor has to be satisfied about ability, integrity, and character. Number two, appointments to the senior grade time scale shall be made by the governor from a list of suitable members of the service. I'll read this slowly, my lord. As prepared from time to time and received as and when necessary by a selection board consisting of the following, namely so and so. So I'll just pause, my lord. The procedure is a list has to be prepared by the department concerned, my lord. A list has to be prepared as prepared from time to time. That list, my lord, and received by the selection board. That list has to be received by the selection board. So the selection board does not prepare the list. Department head, etc., they will prepare the list. That is to be received by the selection board consisting of these gentlemen. Once the selection board receives the list, then Rule 23 comes in. If I'm allowed to read Rule 23, the seniority of members of the service promoted to the senior grade timescale shall be in the order in which their names are arranged by the selection board under sub-rule 2 of Rule 22 for the purpose of promotions to that grade. So once the list is received, the selection board has to rearrange that list. Rearrangement of that list as per seniority cannot be done, obviously, cannot be done at the whims and fancies of the selection board. They have to be guided by the rules. They have to be guided, we go back to 16.4. 16.4, very clear. Seniority, that is at page 9, my lord, which Lordship had just perused, had just read. The seniority of the members of the service recruited after the commencement of these rules shall be in the order in which their names appear in the list prepared under so and so or approved under so and so, the merit list, my lord. So therefore, the selection upon promotion also, at the stage of promotion, the seniority in the senior grade will have to be determined by the selection board based on the rules, my lord. That is 16.4. 16.4 cannot be clearer. Merit list has to be followed. So if I'm allowed to categorize the stages of my service, till the time I was promoted, that is on 7th March 2022, till that time I was to be considered as junior to the respondents. We were promoted on the same day as part of the same process. Justice Banerjee in his 2022 judgment also has spoken, if you're appointed through the same process, then inter se seniority comes in. Inter se seniority of promoted members is to be determined, has to be determined, my lord, through valid criteria, my lord. That valid criteria is only available under 16.4 of the rules. Selection board, my lord, has to fall back on 16.4, and this is the practice that is followed consistently by the service, my lord. So to answer Lordship's question, what would be the procedure adopted once I am promoted? That is under 22 and 23, my lord. Procedure is clear, my lord.
Yes.
My lord. So,
in this case, was there a list prepared under sub-rule 2 of Rule 22?
by the selection board, my lord. It must have been prepared because the selection, the promotion selection.
That appears to be the crux of the issue here. You say most of the, it's like you're going by assumption.
It is an assumption, I agree. Can I take instructions on that? Because I'm personally not aware of that. I'm personally not aware. No, but
At this stage, at least this court cannot say like whether
my lord,
or this provision of 16.4 will be applicable to the
my lord, my lord, my lord, my lord,
But then, if there
my lord,
is a list under 20,
my lord.
that will clarify the situation.
That list, even if there is a list, just two small responses, my lord. That number one, my lord, even if there is a list, assuming that there is a list, there should be a list. It is quite possible, my lord, I'm subject to correction, of course. These are again my personal views. It is quite possible that the selection board itself was wrongly guided by the 2022 judgment. Because of that, ultimately, the gradation list of 2022 was published, which I would say reflected the wrong position, my lord.
See, like how can we say that the selection board has proceeded on the basis of this judgment?
To answer Lordship's,
Assume that until
my
unless
lord,
you can show us.
my lord, to answer Lordship's first question, whether there is a list that was prepared by the selection board, I will have to see instructions. I'm not aware.
That appears to be more vital. Once we see this, nothing, no controversy. You see, like you do not have to go for lengthy things. You see, like Mr. Jindal, you
My
have placed your case very well.
My lord.
You have made the things very clear.
My lord.
So now, what this court understands is that that is
My lord,
whether if there is a colony list, whether it's under challenge or not, because your contention, the
My lord.
acceptance of your contention
My lord.
is subject to what is the situation in 22.
The list prepared by the selection board, my lord. My lord, I'll have to seek instructions.
If you find that there is something against you, then until unless you put a challenge to that,
My
you
lord.
cannot have any grievance.
My lord, I'll have to seek instructions whether there is a list which was prepared by the selection board under Rule 22, my lord. Number one. And number two, my lord, I would beg to differ a little from Lordship's views in the sense that
Why not? We are ending up
I
These are all passing observations.
my lord, the whether or not the selection board has prepared a list under 22 or 23, my lord, it would not really be touching on the issue which I'm raising. The issue which I'm raising is that merit list has to reign supreme. Merit list is supreme. Merit list cannot be deviated from under any circumstances, especially at this stage when I have been promoted, my lord. Till promotion, maybe Justice Banerjee's judgment was against me for that 28 days till my promotion came through.
Justice Banerjee's judgment
Yes, ma'am.
basically alters the entire 2024 edition. See, like your seniority.
2014, my lord.
2014.
My lord.
Okay, so.
My lord.
Okay, so that is what. But then, as you say, after promotion.
Yes, my lord.
To the seniority.
Yes, my lord.
Now, if there has to be alteration of the positions.
Yes, my lord.
Then you see that 23, Rule 23.
So the alteration of position has to be in conformity with the rules. The gradation list which is prepared, which claims to be made under 16.4, has to comply with 16.4. 16.4 says seniority is as per merit list. So your gradation list of 2022 has to reflect that position of the merit list of.
He also says about me. See, that is on the selection committee should take into consideration.
My lord. So once the promotees, the proposed promotees.
As of now, this court doesn't see any conflict between 16.4 and 22.
No, there is no conflict. I would not say that there is any conflict. My point is a little more simpler than that, my lord. My point is that when rearranging the names on that list, the selection board also has to be guided by 16.4. The fact that gradation list reflects a position contrary to 16.4 leads to
On what basis you are saying that the 16.4,
yes, ma'am.
the selection committee was not guided by 16.4 in this case? Why you say?
Because I am lower than the respondent. I am lower than the respondent. Whereas
That is what, see, the Justice Banerjee's judgment has relegated you to that position only.
till the time I am promoted, my lord.
What happens in promotion? How do you know it without looking at the thing?
Lordship.
On what basis the merits are considered?
Lordship.
Say, supposing if we are not considered as meritorious
My lord.
to others,
My lord.
in such a case we cannot also assume that you should be placed on the top, the others should be below.
My lord, because
You see, like me asked to come to that conclusion.
My lord.
Give us sufficient materials.
Understood,
You
my
say
lord.
that you were considered the most meritorious person, but in spite of that,
My lord.
they've been deprived of your right. That is
My
what
lord.
you say.
My lord, Lordship will allow me to take instructions in this.
That is what appears to be possible.
Very,
You have placed in a very nice way.
Lordship is very kind.
So far as the things are concerned.
Lordship.
You see, the queries of the court doesn't mean that the court is always
No,
differentiating.
never.
As this court tells you, like this court
My lord.
doesn't have much idea of those.
No, these are very pertinent questions.
Look upon the counsels to guide us.
Naturally, my lord, naturally.
How long will it take?
I will not take more than 2-3 days. Because I'll just get the information whether there is a list.
How long is that with our board? You see how it is.
I was hoping to finish this, but it's a very relevant issue that Lordship has highlighted. Subject to Lordship's convenience.
Mr. Zula, you will say something.
Lordship, I have 3 things to raise in the writ petition.
But
That will be enough to demolish his case.
Then I'll come
If you
to.
say, then we'll not give him any time. If you say that he is, or otherwise we'll just give him some time to take.
Lordship, since my friend is asking for some accommodation, I will not have objection, Your Lordship.
Start the demolition.
Otherwise, Your Lordship, I am to start, Your Lordship. I'll start first from the first 3 things, Your Lordship.
So I'm yet to finish my submissions on res judicata and all that.
See, we have to get to this thing. And, what shall we say? Shall we just simply just say that it will take 5 days?
I've been heard at some length, and further instructions are.
When shall we have this? When can we? So after 2 weeks, Mr. General.
My lord. It's just for me to inform, yes, there is a list, or no, there is no list. If there is a list, I'll require some more time to maybe file an RTI and get that list. If there is a list. If there is no list,
Then what dresses he will decide?
we'll have to cross that bridge when we come to it, my lord. It's a little tricky.
Because the burden is on that. You see, like we cannot ask them to prove something which you are.
My lord.
Then we'll do one thing.
Yes,
We'll have it this week.
my lord.
We'll have it some letter or something.
My lord is very kind.
Thursday, Friday will not be available, my lord.
But then again, it will be a problem. You see, like Wednesday will be having those council matters and all that.
Then let it come on 24th, Your
On
Lordship.
Monday, my lord, next Monday, if that is convenient.
See, there is no problem. The thing is that only thing is that is what we say.
My lord.
We'll just see next week. Just see, give one just. After, okay, anything just. After, just wait for business matter.
Apply, Your Lordship.
Second call. Second call, item number 1.